Hello, and thank you for joining us today on the Ask Andrew Show, Canada's first Facebook live streaming family law Q&A show. My name is Andrew Feldstein, and I'm the principal at Greater Toronto Area family law firm Feldstein Family Law Group. We here practice exclusively in family law across the province of Ontario. Today's show, we're doing it a little different, and we're going to divide it into three sections. The first section, I'm going to tell you a little bit about Feldstein Family Law Group. The second section is where we're going to answer some questions that we've already received via text message for today's show. And then lastly, I'm interviewing Defamation Barrister David Potts, who is going to provide some interesting insight into an issue that's becoming more and more important in family law, which is when former spouses are saying negative things that are really defamatory, whether it's on a website, whether it's on LinkedIn, social media, Instagram, whole host of different places people can defame people on now. And we're going to get David's thoughts and viewpoints on that. Now, to begin, I want to talk a little bit about Feldstein Family Law. We were founded in 1994, and we practice exclusively in the area of family law. And that means every lawyer, every law clerk, every articling student, what we do is family law every day, all day. And that's the sole area that we practice in. The reason why we do this is early on in my career, I realized there's a lot to be said for knowing how to do one thing. And if you do one thing, you can really know it and you can really service your clients far better than a lawyer who may be doing 2, 3, 4, or 5 different things. So I always say to people, ask yourself this question when interviewing a lawyer. How many areas do you practice? How much family law do you do? And here we do everything in terms of family law. We do all areas of it. And we have lawyers with varying experience. For me, I've been doing it for 23 years, and we have some lawyers that are fresh colleagues. They may help me on files, being the junior lawyers, or if your file is less complex, you may prefer their hourly rate, and they can assist you and help you get to resolution. And when you do hire a junior lawyer, you have the benefit of them being able to seek the assistance of a senior lawyer when needed. Now, one of the things that I believe really differentiates us from other firms is we really do want to get the best possible result for our clients and try to manage that with what the cost of the file is. And in doing so, we offer different ways of achieving that objective. One way is through something called a limited scope retainer or unbundled services. And that gives a client the option to hire us not to do everything on the file, but to do specific steps that they may want us to do on the file. So they may want us to coach them in the background, draft a particular document, go to one court appearance, or draft the materials for one appearance. We're happy to help people because we realize people may not be able to afford us for what I'm going to go through next, which we call a comprehensive retainer. And we want to help them get to resolution or get the best possible result and help them where we can. The other type of service that as family law lawyers we do is what we call the comprehensive retainer. That's the traditional model where we do everything for the client. If a client asks me what's better, the comprehensive or the limited scope retainer, it's always the comprehensive is the best because you're getting the best service. However, some people may not be able to afford that. I've always equated it to driving a car. If you say to somebody, what car would you like? I think most people would love to say they want a Porsche, a Ferrari, a Lamborghini, but they may also say they can't afford that car. Well, comprehensive retainer is the higher end type of service, and not everyone can afford it. And for those who can't afford it, it's like getting a Ford or a Chrysler or a GM, a Honda, Toyota, more middle end car, but it may be very safe. It may be able to operate, and it's important to be able to buy that type of service if that's all that you can afford. We try to do that. That's a way to help people. That's a way to get people who don't have lawyers the ability to hire a lawyer and get some input and help them get to a resolution. By doing this, we are trying to help everyone, and that's why we have our website, separation.ca, as well as familylawhelp.ca, in order to give people information and help them towards resolution. And we hope that this will help people have some understanding of who we are here at Feldstein Family Law Group. Now, I want to go to the next part of the show, which is some questions and answers. And I thought there were some interesting questions that came in today. The first question was, and this came in on Facebook, How do the recent proposed tax changes for business owners affect family law situations? And I think it's a great question, and a big part of the problem is the current government hasn't released in full what it is that they're going to be doing. That makes it somewhat challenging for us to answer that question. However, there are some very fascinating ramifications for it. Number one, it's really forcing, and this only applies to business owners that own a company, it's forcing them to take their pre-corporate tax income that they wanted to invest in a stock portfolio, and it's forcing them really to take it out of the company. And by forcing them to take it out, it's going to make the argument that that is income for support purposes much easier. It may also help for people who are leaving money behind in the company to argue that they really do need to leave it behind in the company and it's not available for income, because why would they want to pay the punitive tax consequences that are going to flow from leaving money behind in the company that are suggested by these amendments? The other thing these amendments are going to do is it's going to stop the income sprinkling among family members, which quite frankly, in most divorce cases, it stops it anyways. And the other thing that I've blogged about this in a video blog that I have a concern for is that if it forces a owner of a business to take out the existing investment portfolio from the company, it can leave the business owner in a very negative position. And in my video blog, I talk about an example where on the date of separation, there's $1 million stock portfolio that has to be equalized. And if we went and we gave the notional tax discount at that time of, say, a couple $100,000, it would mean $800,000 was being equalized, meaning the owner of the business has 400, the other spouse gets 400. But if this legislation forces that person to take that money out of the company, they're now going to have to pay taxes at a dividend tax rate of about 45% on that $1 million. So now they've paid 400 of the million to their former spouse. Now they're going to pay 450,000 in taxes, which is more than the notional amount because they got to liquidate it sooner than they planned. And then the worst kicker for that person is now that income that they already equalized is going to be considered income for child support purposes, and they're going to have to pay a significant amount of child support. At the end of the day, it leaves a person who owns a company with a very, very small chunk. And on my video blog, I think I did it about $24,000, $25,000 left over for the owner of the business. And their spouse ends up with about $550,000 from that business. Something doesn't seem fair. I've heard a rumor that the government's talking about grandfathering existing stock portfolios. I hope that's the case. Otherwise, they're creating a horrible hardship to business owners. I know I've been on Facebook and saying, in my view, this government is attacking business owners. This is another example of it, unless they correct that problem. The next question that I've received from the audience, well, here's one that just came in, which is someone says they separated in 2014. They did their own agreement, and their former spouse did not want spousal support at that time. And now they want spousal support and have served them with papers. And that is a great question. Now, I often have clients come in and they say to me, why shouldn't they go do an agreement on their own? And this is exactly the reason why, because if I'm right, this is probably going to be something they found on the web or a grand and toy agreement. And if they found it on the web, it's probably not based on Ontario law. There probably has not been financial disclosure. The wording of the release is probably wrong. And now when this person goes to court, they're probably going to be successful. The person who wanted that release to stick should have gone, should have hired a lawyer, should have had a proper agreement drafted, and would have been able to deal with disclosure and would have been able to put forward an agreement that would be much more likely to withstand scrutiny. When I see these homemade agreements, they're frequently set aside, especially when the wording doesn't even have the proper release. So in essence, this particular person who asked the question on Facebook is getting, in a way, what they paid for in their agreement, a very poor service. I always say to people, you want to release a spousal support, get an agreement signed. It's well worth paying for it. And this person will attest to it, because even if they're successful at the end of the day, how much money are they going to spend in legal fees fighting about this? The next question that we had came in via email. And it's, my ex and I are splitting up amicably. We have one child, rent our home, and own 2 cars. They've set up a custody arrangement, but they're starting to have issues with it. as he's not sticking to it. Should I see a lawyer? Is it always a good idea to see a lawyer? Well, a lawyer is always going to be able to advocate for your rights better than you can. A, lawyers are objective, and B, most importantly, we have a lot of experience in dealing with these problems. It is possible that we will write a letter to the former spouse or an email, and they may listen to it. But if they don't listen to it, we also have the ability to go to court and try to enforce the terms of the agreement. This other person who is breaking the agreement may have concerns when they see a lawyer, or they may not. But the only way you can ultimately deal with this problem is either taking them to court, or if there's a dispute resolution provision in the separation agreement, following that dispute resolution provision. So once again, what's the proper order? If I was this person, I would start by sending an email saying, you need to follow the agreement. And if you're not going to follow the agreement, then I'm going to go hire a lawyer. They may decide at that point to listen, but if they don't, then go hire a lawyer. Have a demand letter sent out. If they don't listen at that point, then you may need a court action and the court to assist. Hopefully it doesn't get to that. In some cases it will. Another question that we got before the show from Facebook is this one. I live in Saskatchewan and was hoping to get some help with something. I can't afford to pay the agreed child support as we have 2 kids and split custody or spousal support anymore. What can I do? Well, I'm going to start by saying I'm only a lawyer in Ontario, and I can't give advice about what goes on in Saskatchewan because I don't appreciate Saskatchewan law. So my answer is going to be based on as if this person lived in Ontario. If there has been a material change in circumstance, then you can go back to court to reduce your child support and spousal support. But if your answer is simply, I'm paying too much money and my income is the same, you're going to have a big problem because you're going to lose. The answer is going to be that you need to look at child support and spousal support as if it's no different than a mortgage payment. When people have a mortgage payment to make on the first of the month, they plan that they have to make that mortgage payment, period, end of story, because there's consequences if they don't make that mortgage payment. Well, if you have child support and spousal support obligations that you're required to make on the first of the month, or any other day for that matter, it needs to be viewed like a mortgage. If you don't make it, there will be consequences that flow. The consequences can be very serious. It may be slow to get it started, but they can garnish your pay. They can suspend your driver's license. They can suspend your passport. They can suspend any hunting licenses you have. And ultimately, they can actually get incarceration. You might think there's no debtor's prison in Canada, but there is a debtor's prison for support payers. And I'll never forget the case when I was hired by a gentleman who actually was incarcerated because he hadn't paid his support. Now, I've never done criminal law, so it was the only time I ever visited a client in a jail, and I have never seen such fear in a person as that particular gentleman wanting to get out of jail. And he told me where all his money was hidden, and I had to round up the money and negotiate a payment with family responsibility to get him out of jail. You don't want to be that person. So your choices are really simple. If you've had a change in circumstance that's significant, bring a motion for a change in support. If you haven't had that, arrange your affairs that you must pay it. It is like a mortgage payment. I say that not just as a divorce lawyer, but a support payor. I have to make my payments, and the day my check comes in for my pay, out goes my support payment. That's just the way life works, and it's just the way it has to be, because otherwise you're going to be dealing with the consequences from the government, who is going to want to chase you down and collect money from you. And that's something you do not want to find out about. I hope that this has helped answer the questions. I believe we may have one more question coming in right now. And after this question, I'm going to shift over and we're going to introduce David Potts at that point. And then we're going to get into the segment of the show that deals with cyber law. The current question, it seems to be, is, I'm waiting for it to come up on my video screen here right now, so I apologize that it's taking a little longer. I'm a stay-at-home mom, and my husband works full-time. We have 3 children. Am I entitled to spousal support, or will I have to pay spousal support? How does that work? Well, if you're a stay-at-home mom and your husband has been working, then he's certainly going to be the one who is paying support because you have no income. However, what must be added is that I'm assuming the children are going to be staying with you, and he's going to pay child support and he's going to pay spousal support. but you're also going to have an obligation to go get a job and start working. It may not be the day after separation, but at some point you're expected to work towards self-sufficiency to get the most income that you can achieve. That may not mean that you'll ever be self-sufficient, because you may be entitled to some compensatory support as well as support based on need. But the lower the income your husband is, the more important it will be for you to find a job. So if you're a stay-at-home mom and your spouse is making $50,000 a year and you split it up with child and spouse support, it's not going to work, and you're going to need to work right away. If your spouse makes $500,000 a year, your support will be significant, but you may still find you need a job quicker than you think because of the lifestyle you've grown accustomed to, but your income will have much less of an impact. As I said before, I hope these answers are helpful. And I now wanted to introduce David Potts. David, welcome to the show, and thank you for sitting there patiently while we took on some other issues and answered some questions for people.
It's always good to meet with you, Andrew, and to actually see you live. Andrew and I have worked together in a number of cases, and he is, in my experience, one of the preeminent family law lawyers that I've had the pleasure of working with.
Well, thank you, David. I appreciate the compliment, and I know it's always been a pleasure working with you on files. And I have some questions for you because I think people want to know these kind of issues, but what is cyberbullying as it pertains to family law?
Well, I think we were talking about cyber libel as opposed to cyberbullying. Cyber libel is defamatory statements. In other words, a false statement to a person's discredit published online. That's what it is, simply.
And when you say online, what does that mean?
Well, what it means is on social media, on blogs, on websites, ultimately on Google. And what I'm finding that is happening, and it's become worse over the last couple of years, and is that people are using their social media tools or their telephones as, in effect, almost a weapon to attack their spouses, or in some cases, worse, that they try to do. They try to develop a crusade on their behalf. And I've had situations where clients have set up websites and they've tried to enlist support, and they and attack the other side, and it truly can get very vicious.
And what type of damages does someone get for that?
Well, they can range, but two of the interesting cases that I've just looked at for this show for family law, one was in Australia, which was it was a situation where somebody made statements on Facebook, and the husband got $12,000. Another case in British Columbia, which is very interesting for several reasons. They got $5,000, and the reason it was interesting is that at the beginning of the case, what the courts did, they anonymized the parties, and this is a very important feature that you should probably always do if there is any likelihood of going to court, is to try to go for a motion to try to anonymize the parties, so that the fight that was initially just confined to the papers in the law firm and the lawyers are not just blasted all over the internet.
And I think I want to expand on what you just said, David, because I want the audience to understand that what happens in a family court is actually open to the public. And if you have a trial or a motion where a judge, instead of does the decision in handwriting but types it up, that decision is going to be available on CanLII for everybody to see. So if you have a trial decision or this kind of motion and someone Googles your name, up will come your case with CanLII, with all of the dirt and salacious allegations that may be involved. And one of the things you can do to try and get around that is to ask the court to make an order that initializes the case. So instead of having your name on it, the court will know to put initials on and not do anything to personalize the case to the litigants. So for example, if the CEO a huge company was going through a divorce, they may not say he's the CEO of a very large company that is in a certain industry, because that would make it identifiable. The problem is it's harder to initialize the case than you think, in terms of it's not an automatic thing the courts are going to give out. Personally, I've written articles on it, and I cannot understand why family cases are in the public domain, especially when you think you give your financial statements, which include your credit card statements, your bank account numbers, everything is in the court file for someone who wants to be an identity thief to go down to the courthouse and look at the court file because they can. But that's a different issue.
But can I just address that with you, because it really is. It's a fundamental problem in all types of defamation cases. But you're quite right with the particularly in family law, and fortunately we have got some precedent, but they're in England, the cases, and there's a whole series of protocols where the English have, when they go to court, they can ask the judge to initialize, to hold parts of the cases in camera, to block out certain of the features, and it's a very common thing when there's situations when there's custody or financial issues, and it's but that brings me to another feature, is that that's one of the reasons why you don't want to bring libel actions in many cases, because you'll expose yourself to this particular problem. And one of the things I always tell people about is you've got to be concerned about transforming a problem into a disaster. And that is one of the most common things that I see, is people who take something that may have been on emails, they respond, and then they just try to sue, and it now becomes blasted all over cyberspace.
Now, the piece that's interesting here to me is, and I'll never forget this, because early on in the internet years, I had a client who put on a talking animal on a website with their spouse's voice to try and show how the spouse whined. And as soon as we saw it go up, we told the client to take it down, because the optics of it to a judge were really negative. So irrespective of the damages that you may get of $5,000 or $12,000 for slander and libel, there's also a bigger picture that goes on, which is, what is the message that you're sending to your trial judge? And the message can be really negative, that demonstrates you have no respect for the former spouse, and you may make the trial judge very upset with you. That may impact your claims on custody, and where the judge has discretion, the judge may exercise discretion without saying it in a negative way because they don't like what you did. And that's a subtle part that goes along with this issue. Now, David, do you have any solutions that you give to clients or family law lawyers that they should be thinking about at the time they're entering into a separation agreement for their clients?
Yes, one of the things they should be thinking about is having, in effect, a social media protocol. And this protocol will cover when they can use social media, to whom they should use it, and the types of things they can and cannot say. And so you'll set it out almost like an injunction. So the terms will be very precise. And then if there's a breach of those terms, you can come back to deal with them. Because what I find often is there's a non-harassment clause, but the clause is very vague, and it's a harder clause to enforce. And so what I'm advocating when I'm retained by family lawyers is having something that is a social media protocol, and that's something that I think would help people and also be consistent with the system. One of the things I wanted to add, which is your comment about the courts, is the roles you and I both play. Our specialties are almost diametrically opposed in the sense that our differences are laws, our rules, our tactics. And one of the things that I've often or usually do is I always defer to the family law lawyer, and I try to keep the libel proceedings in the family court, because if you bring it as separate actions, you'll often, not only will you make it infinitely more costly, but you will alienate the judge who is handling the family law action, and it will look like a bullying tactic. So that's why I believe that much of the work that I can do is in conjunction with specialists like you in your particular forum, as opposed to launching off on my own lawsuits.
Well, the interesting thing you raise about that is there's a case probably about 10, 15 years ago that came out, and it said that you need to actually put all the issues in your family court proceeding. So you can't do a family court action and then have a separate action for a tort for damages arising from assault or slander and libel, that you're keeping it separate. This case says you got to put it all together. I see we just had another question that came in. And it's someone advising that there's a new book on cyberbullying. If someone's interested in that, they can see that on our Facebook site where they mentioned it. But I want to go back to some questions for David. If someone thinks that your term was not cyberbullying, but if someone is making defamatory statements online, what do you suggest they do?
Well, the first thing they should do is do an assessment and assess where it was, how, and the impact. Because the primary thing you don't want to do, and I will say this again, is you don't want to transform a problem into a disaster. And then you can easily do this by either responding yourself or attacking the thing. So the first thing you do is do the assessment. The second thing you should do is do damage control, which means you should look at the impact on your life and in your family's life and try to shore up those things in conjunction with working with you, so that you're protected. And then finally, you then decide, well, what course of action should we be taking? And that will really depend entirely on the technology that's being used, the platform that's being used, the type of language that's being used, a whole host of factors. But if I can emphasize really doing the assessment and also engaging in the damage control in conjunction with you, so that people are protected when they go forward, are the two primary things that I always spend a lot of time on.
Now, I also want to know if you're the person that has done the defamatory statement on the web. So you made that Facebook post or something and you say, my former spouse cheated with 10 different people and is a horrible person. And now you get the demand letter from somebody like David Potts or from a family law lawyer. What should they do at that point?
Well, I think they should, at that point, obviously they should consult you and me on the libel part, and then they should see if they can resolve it by way of some sort of apology or some form of contrition or some way of retraction. Because what most people want, and this has been proved by studies, is that most people simply want an apology for these statements. And one of the best ways of doing it is, don't write some technical mealy-mouthed apology, just say something, I'm awfully sorry. And that may be the thing that will end it best. And I'm taking this back to what you said is the global optics. And that is, if that happens, that's going to be part of your family law proceedings. And the last thing you want to do is hire somebody who's then going to jump in and launch a whole bunch of complicated defenses in libel, who is going to prejudice your overall family law position.
Well, I would also think from the family law position, there's a lot of damage control that's going to have to be done, especially when you know you may have kids that could be watching it. I know every time I make an appearance on a show like this or anywhere, I'm always thinking my kids may Google this and they may watch that. I get sometimes a person's not going to want to just say, I apologize, because they have their pride and they're probably going to throw an excuse in there like, you know, it was a really bad time. Certain things happened in my life and I was struggling and I'm really sorry I said it. That probably, I would assume, would achieve the same objective, but at least give them some face.
I think what they have to do is if you have an apology that is too equivocal and too mealy-mouthed, it can actually make things worse. So the question is, do they really want to?
Well, does it water it down if they're saying something like, this was a really stressful time? I was just at this place and my father was really sick and I had a bad day and I released and I shouldn't have done it. I was wrong and I'm sorry.
Yeah,
I think still giving.
That's good. The main thing you said that in there that really has a huge impact. I am sorry.
Okay. Now, I wanted to thank you for coming on the show. I see it's 1:30, and so it's the end of our show. I've really enjoyed this topic. I think it's fascinating, and thank you for coming on the show, David.
Pleasure, and it's great to see you in person, even if it's just digitally.
And the next Ask Andrew show is on Thursday, October 19th at 1 p.m. If anyone wants to request a certain topic, feel free to email us at info@feldsteinfamilylaw.com or message us here on Facebook. And thank you for watching and have a great day.